Hello. Good afternoon. A very warm welcome to the first event in the McKercher Lecture Series. I'm McKercher Lecture, professor here at the College of Law and chair of the Speakers Committee. As we gather for today's first lecture, we, as is customary in the series, acknowledge that we're on Treaty 6 territory in homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationships among one another. With me is Michelle Ouellette. Michelle is a friend of the college, respected leader in the Saskatchewan legal community, and a partner with the McKercher law firm, which sponsors the series and which support we're very grateful for. Lets us put on a very dynamic lecture series.
Thank you. Thanks, Michaela. So, good afternoon, everyone. Welcome to this, the first in the College of Law's McKercher Lecture Series for 2017-2018. My firm's very proud and honored to be able to support this series for the last 3 years and to continue to support it this year. Part of our ongoing commitment to Saskatchewan's learning community, the McKercher Lecture Series allows us to engage with both the law school and you as students at an academic level as well as on a personal level. And over our 90-some years of service to the community as a law firm, our firm has grown, it's evolved, but we're proud of our history, of course, but the connection to this series actually allows us to engage with you, the students. It grounds us. It gives us a glimpse into the future of the profession of law and allows us to stay connected to and to adapt to that future through you, the future practitioners. So hence our sponsorship of this series is really important to us, and we hope it is to you as well.
So I want to acknowledge a couple of guests, additional guests that we have with us today before we move on to introducing our special guest. These folks we think of as our own because they are graduates of the LLM program here at the college. And one is Jamesy Patrick. Jamesy works at the Native Law Center and teaches the entertainment law course, which should be maybe of some intrigue to those of you who are in first year. She specializes actually in child welfare law. And also with us is Kurt Dahl, who is a graduate of the LLM program here as well as his LLB, and practices in the area of entertainment law, truly does in Saskatoon, although travels a fair bit in his work. But both of them have identities, and this is one of the reasons I wanted to introduce them, as artists, as professional artists. Jamesy as a professional dancer in ballet, and Kurt as the drummer of an excellent and well-known band called One Bad Son. And if you are first-year students and you're able to join us for the tea after in the student lounge, you'll have the chance to meet Jamesy, Kurt, and Michelle and ask them any questions that you want about practice.
So as you're all aware, the guest of honor and our distinguished speaker for today is Susan Abramovitch. Much can be said about Susan's background, but I'll focus on a couple of things. Starting off her career as a gold medalist and a clerk at the Supreme Court of Canada, she's moved on to practice in New York and Paris before settling in Toronto. She is the recipient of many awards and recognitions, including being named as one of Toronto's 50 most influential people by Toronto Life magazine. And she is the recipient of the very prestigious Lexpert Zenith Award. She's frequently sought not only by high-profile entertainment clients, but also by the media itself for her analysis of developments in the law and commerce of entertainment. She now heads up the Entertainment Law Department of Gowlings LLP and is also well known for the time she devotes to teaching, mentorship, and community service. A recent newspaper article suggests Abramovitch sets the bar on how to succeed in entertainment law. And that might be said more generally about her practice as well. So we welcome her today. Thank you, Susan, for coming.
As you might be anticipating from the setup, today's presentation will be in a conversation form. We thought that would be a wonderful way to learn from the reflections of someone who has a practice such as Susan's. Jamesy will facilitate the dialogue, and in the last 10 or 15 minutes, we'll have a chance for you to join in the conversation as well with your questions. So please hold on to those questions until the end. And I'll pass it over to Jamesy.
Thank you, everyone, for coming. It's a great honor to engage in a bit of dialogue with such a prestigious lawyer in Canada. And I'm going to try to keep my talking to a minimum because you can all come visit me and my stories will probably be less interesting than those that we're about to hear. So I just wanted to get started with asking Susan what drew her to the practice of entertainment law in general and what those challenges were in that journey leading to being one of the top entertainment lawyers in Canada.
Thanks, Jamesy. First of all, thank you all for being here. I am extremely impressed with this audience already, and I know that there's others listening to this on live stream, so thank you for coming out. Thank you for the beautiful introduction, Michelle. That was one of the nicest introductions I've ever had. And for supporting this program. And Michaela and Katie and Jamesy, thank you for thinking of bringing me out and then doing all the legwork to get me out here. So thank you. I'm actually quite impressed already. All right, what drew me to the practice of entertainment law and challenges in getting there? When I was a kid, I did all the art stuff. I did children's theater. I wanted to be an actress. I did piano. I did, all my. I lived in Montreal, so I did McGill University Faculty of Music exams. But I knew pretty quickly that, I was more interested in pursuing a more traditional education and, having more time to spend with friends and having boyfriends and that kind of thing. So I sort of quit piano, quit acting, and just focused on school. When I got to law school, it became clear that I gravitated to entertainment law. We didn't have an entertainment law course at McGill Law, but I sort of tried to pick up as much as I could through various other subjects. And one subject that we learned about was personality rights in torts. So I was like, okay, well that must be entertainment law. So in my last year of law school, I had to write a long paper. I don't know if you have to do that here. And I did, and then I got it published on personality rights. So then I was one of the leading, academics in fourth year law school, because I went for 4 years to do civil law and common law in the subject. Then I broke out and did a few things along the way, but ended up in New York working for a firm called Debevoise and Plimpton. And in New York, I clearly was not doing entertainment law at a humongous New York corporate law firm. I was actually doing M&A in Peruvian mines. And I remember at 3 o'clock in the morning one night when I had to work through the night, which was frequent, I really like law, even if it's 3 a.m. and I feel really abused as a first year or second year lawyer. I actually am enjoying the law, but wouldn't it be fun if the facts that I was dealing with weren't Peruvian mines, but were something that were actually interesting to me? No offense to anybody who's interested in Peruvian mines. And so that's when I started thinking, you know what, I gotta push this out. I need the training. I like what I'm doing. I'm making a lot of money actually in New York. So all this is good. Every day that I can stand this, it will be better for me. But ultimately, when I'm ready to get out and when I've had enough, I gotta do entertainment law. I wanna do law, but I wanna do it with facts that I find interesting. So that's kind of what drew me in. That, and of course we just talked about the parties, but that's another story. You can ask me about that later. Challenges, and I'm not even kidding, challenges along the way. My biggest challenge, there were challenges getting into the field and there were challenges once I was in the field. First challenge to getting into the field was my own attitude, which was that I could operate anonymously. Everything that happened to me through law school and all my successes were very paper-based. I was a gold medalist, and thank you for acknowledging that was a nice thing. But on paper, I was a gold medalist. I, then clerked at the Supreme Court. I mean, I looked really good on paper, and I believed, especially in the U.S. I worked in New York law firms during my summers, and they never had, they eventually had to meet me, but they drew me in and paid for flights and hotels on the basis of my paper. And my paper looked really good. And I thought that's what life was about, was that if you have good pieces of paper with good qualifications and resumes, that will ultimately get you the job. And that's not the way the entertainment world worked. And that was a rude awakening, that I couldn't just send a great resume in and get a job. I got no no, no, and I applied everywhere. And I applied over and over, year after year, before the clerkship, after the clerkship, and everything was no, yet I could still get a big New York corporate job. And so I had to learn that the entertainment industry, and I think this is true of other areas, but certainly in the entertainment industry, it's great to be a good lawyer and have a good background and be a gold medalist, but it's really about the relationships and networking and talking to people and getting in there and having that. So I had to learn that. That was a challenge for sure. The other challenge, of course, was that there are very few entertainment law jobs. So it's actually not so easy to get in. I do have advice for people later about how you do get in and whether you will get in if you're interested in getting into entertainment law. But it's not easy. It's not like you can just say, okay, I'm going to be an entertainment lawyer, and then you get the job the next day. Once I was in the field, I had many challenges as well. First of all, I found that the quality of the lawyers in many cases, and obviously not all cases, could be not the greatest. And I found it very challenging. Remember, I was coming from New York. I had just worked with some of the best lawyers in the world. And dealing with lawyers on the other side who don't get it or don't know what they're doing is actually harder than dealing with a very, very super smart strategic lawyer. Because you're always dealing with somebody on the other side who is suspicious, who doesn't understand how it's going to get done, who doesn't get things done quickly. So that was challenge number one. Challenge number two was I had been trained very, very, very well by a law firm where the clients were multi-million-dollar clients. And it was very important, certainly in that day and age when we didn't have iPhone autocorrect, that every I in every document was dotted and every T was crossed. You never had a typo. Like, they almost literally would take out a ruler, I'm talking about my law firm, and slap me metaphorically across the wrist if there was one single typo in any communication, no matter how informal. That's how I was trained. I know that training isn't necessarily like that anymore, but that's how I was trained. Then you take that and you go into a little boutique, tiny little boutique law firm with music clients who want your help but don't have a lot of money. And you can't spend 3 hours making sure you don't have typos in your document. You still want it to look professional, but you just can't charge them for 3 hours of dotting I's and crossing T's. And that also bleeds into the substantive part of your work. It's very easy to be a good lawyer who notices every issue and raises, says that you need to fix this, and here's a contract, and I need to redraft this and this and this. What's much harder as a lawyer is to learn how to pick and choose which ones are important enough to make it worth your client's very valuable money. And they may say, I can only pay you for a couple hours. If it's only a couple hours, you can't pick on every issue. You can, and then not charge except for the 2 hours, but then you very quickly will not have a business. And so that I found very challenging as well.
Great, thank you. So you just mentioned actually a little while ago something about relationships and relationship building, and I'm curious to know, you've talked about the centrality of relationships in lawyers' work. We don't really talk that much about that in law school necessarily. We focus on substantive law, and relationship building might not be a central part of that. Can you talk about how you see relationship building as a component of a meaningful legal career and the challenges around that?
Yeah, I really believe in that, and not everybody does. Certainly getting into the field, as I said, it was very important, and I couldn't just be this anonymous person standing out there, with please hire me because I got a gold medal 20 years ago in law school, right? That wasn't working. So certainly in terms of getting jobs, but even once I was in the job, I started practicing law I graduated law school in 91. I started practicing entertainment law in 95, but I started practicing, 91, 92. And even in 95, when I started in entertainment law, I saw the world, my professional life is very black and white. There was the time I spent in the office working for clients, and then that would end, and I would go home or go out, and that would be my personal life with a different constituency. And I was very strict about that. I was strict about that when I worked in New York as well. And that started to break down because as I got my own clients, I felt that I really wanted to get to know them. And especially in the arts world, I felt that I couldn't do a good job for my clients unless I understood them as people. What were their dreams? What were their fears? What was their personal situation? And so I would make a point of getting together with them. Maybe at the beginning it was over lunch or a meeting or a coffee, but then it soon became sort of to bleed into my night, and I liked it. And the wall between who are my friends and who are my clients sort of broke down. And I think it made me a better lawyer, because I started to understand what I call the 360, which is a concept that comes up over and over in the music industry, of my clients' careers and lives. And again, especially in the arts, I think you can't break that down. But in terms of law school education, I think it's important for people to consider that in the fields that every lawyer gets into. Does it make sense? And I personally believe that in any area of law, it's important. Even if you have a corporate client or general counsel at some, corporation, if you don't really know what drives them and what's important to them, you won't truly understand their business. I believe that. So I think it's a really important element, and you're right, it is not taught at law school. If it had been taught to me at law school, I probably wouldn't have been so anonymous and waiting for people to hire me because of my great resume.
Do you face this isn't a question, this just popped into my head, but what kind of conflicts then do you face as a lawyer representing a client and having to kind of break down that lawyer-client specific relationship? Is that something unique to entertainment law that you face, or you think entertainment lawyers have to deal with?
That's a good question. They're clearly not legal conflicts, although that comes up when lawyers start fulfilling other roles, and we can talk about that as well. But being their friends, I suppose you get to know them personally, and sometimes that makes it very difficult. I haven't really broken up with any of my clients on the basis of breaking up with them as friends. But you certainly, become very dear to one another, and so when crises happen, they're in there or they're not.
So you've represented some pretty high-profile Canadian musicians. We've maybe all done a little Google search and have picked that up. And you've had considerable influence then in the course of your career. How has the entertainment industry and its relationship to law changed over your career?
Thanks. So, and I know the questions are focused on music because I started as a music lawyer, pure and simple, and that's one of the things I'm going to point out soon. But I do work in other areas of entertainment, film, TV, book publishing. But actually, that's one of the things. Then, I'll talk about then, and then I'll talk about now. Then, the entertainment industry was really divided into silos. So there's the music industry, the film industry, the book publishing industry, the TV industry, and entertainment law industry broke down along the same lines. I was taught by my mentor who said, you can't be a good music lawyer if you're also dabbling in TV, unless that TV work is about music videos or it has some connection to the music industry. So it was very much, you are a music lawyer or a TV lawyer or a film lawyer or a fine arts lawyer or a dance lawyer or a book publishing lawyer, but you can't be all of the above. That was then, and then, by the way, for me is mid-90s. The other thing in the music industry specifically, the major labels were dominant. There had been very little technological change. We moved from vinyl to cassette to CD, but that's not really revolutionary change. It's a change of medium, but it wasn't a change in how people consume music or how music is used. So pretty much the way the industry worked had been the same for decades before that. That's what I came into in the 90s. Again, okay, fine, now it's not vinyl, so you have to upgrade your collection to another format. But basically the structure was the same. Major labels controlled the industry. And musicians generally had a lack of leverage, unless there was some kind of competitive bid, which would happen once in a while. But basically, if you were representing artists, which I started out doing mainly representation of artists, you would go up against the major label, you'd have no leverage, you'd be a great lawyer, and you'd say, I'd like this, this, and this, and they'd say, no, 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 and there was nothing you can do about it. So there was, most deals were kind of very similar. They're all the terms were the same, and basically there was a little bit of room to maneuver, give or take, in each deal, but it was very, very, every day I was kind of doing the same thing. The other thing that was different then was that different players in the music industry assumed distinct roles. What I mean by that is that there were managers who managed the artists, and there were record labels who were different people from the managers who would make records with the artists. There were music publishers who would deal with the musical songwriting of the artists, different than the labels. There were booking agents who would book live shows for the artists, different from all these other people. There were perhaps merchandising companies, promoters, all these were different players. So that was then. And the other thing that was different then was that artists, and this is, it's a general comment, it wasn't true of everybody, but generally speaking, artists had a bit of a distaste for commercialism. There was a lot of, well, I'm not going to license my music for a television commercial for a product. That's distasteful. I'm an artist. And, you know, maybe that was even more prevalent in the 70s than in the 90s, but it was still very much there. My clients would be like, oh, you know, I'm not going to, you know, there was a big case we handled that ended up getting settled, and maybe that one would still happen today. But we represented Lorraine Segato for her song and her band for the song Rise Up, which had been given to a music publisher, and the music publisher licensed it to McCain Rising Crust Pizza for a commercial, and they said that's a violation of moral rights. This is like a, you know, LGBT anthem, and you're using it for Rising Crust Pizza. Anyways, that got settled. So, you know, okay, in that case, I think even today, they would, you know, there would be some objection to it. All right, so how have things changed? Well, first of all, obviously the technological revolution has changed everything, right? And it's different. I'm not talking about change in format. Like, we went from, okay, buying music on a physical format and taking it home and owning it, to being able to access it for free illegally, to being able to access it not for free, but in a completely different format, but still owned and digitally in a dangerous format for illegal activity, to where we are now, which is we don't even care about owning music. It's all about streaming and accessing a library and having a subscription. And it's a completely different model. So the technological changes today have changed the structure of how we consume music, and therefore the industry and the deals, as opposed to just a change in format. So that's made a big difference to my practice. Of course, those technological changes in the way music is consumed led to a decline in the fortunes of the music industry, which has had a big impact on entertainment law and the entertainment industry. Less money to go around, and therefore less dominance of the major labels and labels generally, which maybe is a good thing, but for a bad reason, because now artists, you know, there's no funding of artists, there's no development. Artists have more leverage. That's fun, but there's a lot less money, and they have to do it themselves a lot more. So there's pros and cons to that. Deals are very different as a result. There's a recognition in the industry that the Copyright Act actually has meaning, that without the Copyright Act and a strong Copyright Act, there is no industry. And so I think one of the big changes in the relationship between the entertainment industry and law law is that you can't just assume that the music industry will be there without very strict and careful protection in legislation. You know, you may not be able to make money off of your wares. For artists as well in the entertainment industry, for all players, because of the decline in the fortunes of the music industry, there's been a strong push towards trying to find new sources of revenue. So there's been, I think, a big trend towards looking at the artist as a brand, and not just the artist, but any music players as a brand, and then a bigger focus on, okay, well, if that's important for making money, how do you protect that brand, right? Focusing on IP and the reputation of the artist. 360 agreements, so I talked about how in the olden days there were different players assuming distinct roles. That's a big change, where we do what we call 360 agreements more often now, with one player assuming multiple roles. So a manager could be the record label, could be the music publisher, all the same person, more eggs in one basket. That's a huge difference. And then finally, there's also the breakdown of the silos between the entertainment industries, where you can't just be a music lawyer because, of course, I had this epiphany one day, like 10 or 15 years ago. I woke up and it was like, wow, all entertainment media is converging into one product, and that product is a video game. And that, when the moment I woke up with that revelation, and which coincided, by the way, I think it was like 2005, at the nadir of the music industry. So take whatever conclusions you will from the fact that I was a music lawyer, and I was like, oh no, I better do something fast. It is true, and it's almost trite to say that, you know, you can't just do music. You do music, but you also have to combine it with maybe a TV show or branded entertainment, and you know, there may be a obviously music publishing component involved, but you may be working with a product company to do commercials. So it's all kind of like collapsed. And in terms of entertainment law, I've therefore collapsed my practice into the other areas, and I'm not just a music lawyer. And then finally, artists are much more open to commercial exploitation. Again, either to find other avenues, but also it's not so distasteful to do an ad. So, in fact, some ads really break out artists and are very, very cool, like starting with the Apple iPod ads that really made some artists, like Feist and so on.
So then, you know, with the change in the industry, what developments do you see or big issues do you see on the horizon for not just musicians then, but artists in Canada as they face legal issues? Or what do you think your role will be moving forward?
I think right now the biggest issue in the music industry is what we call the value gap. Has anybody heard of the value gap, that term? No? Okay, that's big rhetoric in my industry. So the issue is that music is still important. Music never stopped being important, right? Whether it was during the age of download piracy or it was long ago when people bought vinyl, or it's today when people are, you know, all on streaming services all the time. Music, the importance of music has never gone away. Or music used in film. I mean, if you've ever watched a movie without the music soundtrack and then with the music soundtrack, you realize how important it is to have music in film and TV. So that's never changed. The economics have gone up and down, but actually we're on, having reached the nadir in maybe 2005, we're sort of on the upswing. There is lots of money being made from music out there on the internet and predominantly. The problem is who's making that money? That's the value gap issue. ISPs and those kind of platforms are using music at the yin-yang. YouTube, you know, that is the heaviest place for people to get their music from. My kids listen to their music on YouTube. You guys probably listen to your music on YouTube. So YouTube is rich. YouTube's making a lot of money, and ISPs are making a lot of money. And a lot of that money is connected to the fact that they have music on and you want that music. The problem is that there's the money, and the money is not trickling appropriately to the makers, the labels and the music publishers and the artists. And that is the value gap. So the industry right now is very focused on that. That's going to be a big issue. The other one I mentioned before is artist as brand. I think that's a very important focus, that artists, you know, have now see themselves not just as putting out artistic product, but themselves having an image and a reputation that they can use commercially or in other ways, politically or however it's used. And so carefully maintaining control over the image, which in the olden days maybe they gave up a little too often, and ownership of the image to the extent there are rights in that, and understanding what those rights are. I think that's an important area. Navigating, you talked about conflicts before, navigating conflicts in 360 agreements. I just came back from Hamburg and I spoke on a panel and I was talking about looking at conflict issues inherent in management agreements when the management agreement is part of a 360. So a manager acts as not just manager but as record label and music publisher. Well, that creates a whole host of issues because a manager is supposed to sort of strongly defend the interests of the artist. They may have a power of attorney to exercise, to give approvals over the use of the artist's image in some kind of ad campaign that the label may want to do. But when the manager is the label, is the music publisher, how do they exercise that power of attorney carefully? It's almost impossible. Or when a manager incurs an expense by going to Hamburg for that artist to try and pitch that artist, you know, at shows and to an international audience, when that expense is incurred, they spend, I don't know, $20,000 to get the manager and maybe the artist there. Are they expending that as the manager or as the record label or as the music publisher? And without getting into too much detail, expenses are treated differently under each of those agreements, more favorably or less favorably to the artist. Well, I mean, it's hard to say in what capacity the manager was doing that. That's another area. And then finally, to maybe a lesser extent, hopefully in Canada, but it is becoming an issue, it's the impact of terrorism in live performance and what issues, from my perspective, contractually and insurance-wise you have to deal with. And you know, how, you know, we used to throw force majeure clauses into contracts, and you know, as much as I love boilerplate, and I am a big admirer of boilerplate in contracts, I get very excited about boilerplate. boilerplate are sort of the clauses at the end that people don't read. I love them. So one of those is for the force majeure clause, which says, if something really terrible happens or something weird, a labor dispute or whatever, things that in the olden days, they used to say, well, that's never going to happen, so I don't really have to pay attention. One of those things was acts of terrorism. Well, those have happened in the music industry and have impacted things. So what do we do to control that? I think that's an up-and-coming issue.
Talking about artists then, you talked about how the 360 deal, it might, an artist might sign on to something and they're doing not just the music and they're really selling then a personality or an image. Do you think artists, new upcoming artists then kind of lose creative control earlier on in their careers than maybe in the past?
I don't. I think the issue of creative control is still there. You still have to closely guard it. I worry about it, the loss of control over image more in the TV talent world, actually, than I do in the recording artist. I represent a lot of on-air talent, and very often that talent in their TV deals, the TV station wants to control what endorsements they can do and can't do, what product placement, what products they get to touch. So in that area, I get very nervous, but in the music industry, I don't. I think that artists, because of the gain in leverage and the more DIY by force of nature because of the industry, artists actually probably have the same amount of control. The 360s, the danger there is not so much loss of control, but putting all your eggs in one basket.
So when I canvassed my this entertainment law class this year, and it's been the first time it's been offered in a while, a lot of the students put up their hand that they're going to practice entertainment law. So watch out, Kurt. There's going to be a competition, big competition in Saskatoon. So I'm curious as to what your practice tips or points of advice for young lawyers or law students who are wishing to practice in the area of entertainment law or get into the area of entertainment law.
First one, and I think it's come through in my other comments, is network, right? If you want to get into entertainment law, take the courses. They're few and far between, so you're very lucky that you have one here, by the way. As I mentioned, I didn't have access to one when I went through law school. So do that, but start now. You're first-year law students, start now, network. And I don't know exactly what the resources are in Saskatchewan, but I know this is a very cool city, by the way. I really like Saskatoon. So there must be stuff going on where you can network. But in Toronto, there's the Ontario Bar Association Entertainment Law Division. So you can sort of get involved in that. There are conferences that happen all over the place. If you can get to them, if they're outside of Saskatchewan, go and take advantage of student rates. Everybody always charges students less, so it's a good time to do them all. Network. Call up lawyers and say, can I talk to you? Can I pick your brain? When people call me, I typically say first year is probably early to do that, but as you're getting ready to get out of, just before I get 1,000 phone calls, but as you're getting out of law school or you're articling or whatever, I never say no. I always have at least a 15-minute conversation because people were open to me when I wanted to talk to them. So network. And when you network, a subset of that is then hover without being annoying. That's key. That's really, really key. And don't ask me what the magic of that is. I'm not sure that I've conquered it myself. But you can't just make an introduction because you're dealing with people like me who are old already and forget people's names. And then the next 3-4 months later, a friend from E1 will call me and say, Susan, oh my God, I need a first-year lawyer. I'm over my head. I'm snowed under. Do you know anybody who's interested and who's good? And I'll be like, I can't remember. So if you need to hover to make sure that the names, on mine or other people's in their heads when that phone call comes through so the connection can be made. Some people are better than I am at that, but I know that I forget. So you have to hover, hey, I just went, I spoke to you 6 months ago. I don't know if you remember me, but I just, you inspired me to go to the Americana Festival in Nashville, and I just wanted to tell you it was great, and there's speakers panels there, and maybe you should try and be a speaker there, Susan. That always makes me excited. So network and hover without being annoying. That's number one. Number two, get the best corporate commercial training you can possibly get. Entertainment law, and by the way, I didn't even know this in law school, is business law. That's all it is, right? And yes, there is litigation in entertainment issues, but nobody in Canada, at least, can really specialize in that. And in my experience over the 22 years that I've been doing entertainment law, and by the way, when I was in law school, I really wanted to be an entertainment litigator. That's what because I loved litigation, but I wanted to do it in entertainment. And I can tell you right now, at least at the moment, that's not possible to specialize in 100%. you will get cases in entertainment law if you're a litigator, especially if you work at a law firm where there is an entertainment lawyer. So, I mean, litigation comes up and I hand it off to my choice litigators at the firm, and I'm lucky enough at Gowlings that I have a choice of IP litigators or commercial litigators, because entertainment litigation could involve one or the other or both. And those are two different fields, believe it or not, at least at Gowlings. But basically entertainment law is corporate commercial law. And as I said, learn that boilerplate, right? Every single clause. Why are you choosing this law? Why are you choosing this venue? What does the assignment clause say? You know, what does all that stuff about this is the whole agreement? What does all that mean? Just soak that in. Even if you're not getting entertainment-specific contracts or clauses, that is going to be so important. It's so important to me today. Look at that, my force majeure clause. I wish I had more training on force majeure now, because terrorism arises. Is it the threat of terrorism that allows an artist to call off a show? And do I need to worry about that? Should they get their deposit back? I mean, I need to worry about these things now. And that's something that, you know, when I was at Debevoise and Plimpton in New York, you know, nobody taught me force majeure clauses, but the training could have been there if I had actually gone and said, okay, how do we make the perfect clause? What is this change in words in the force majeure clause? What difference does that make? So that's the training you get in corporate commercial, and the longer you can tolerate it. I couldn't tolerate it very long. I was there 2 years, but I knew every day that I was there, as I said, that it was a huge education every day that I could suffer through it. Through the 3 a.m. Peruvian mine M&A deals. So best corporate commercial education you can get. That's not always at the biggest firm, and you never know who your mentors are till you're there, if they're good or they're bad. That's kind of luck of the draw, but the best mentors you can get in the best corporate commercial training environment you can get. Number 3, I had to learn this too. It's sort of a spin-off of the anonymity thing that I had. Everybody reappears. Everybody reappears. So those people that you dealt with and you were not nice to at the beginning because they were not that important and they worked someplace else, and it was like, why do you have, you're not going to have anything to do with me. 20 years later, we'll run a record company or have in some other capacity, and they will reappear, or they will be, you know, married to an artist who you really would like as a client, or. People have reappeared in my life over and over and over professionally. And you really want to have maintained a great reputation with, you know, people who respect you. And you get clients when you treat the, you know, I get many clients because somebody observed how I was lawyering on the other side of a deal, and then they come and hire me. That's the best compliment. I love that. So, you know, be careful how you treat people. I mean, you have to represent your client to the best of your ability and in their interest. So I'm not saying sell your client out at all, but make sure you're doing it with grace and respect and intellect, and those people on the other side will end up hiring you. So people reappear. That's my 3rd piece of advice.
Great. So I think with that, we might open up the floor now to questions. There's students in my class here who I think have some questions, but also anyone else with any questions for Susan. This is a great time to ask those, and I'll bring the mic to you, I think.
Come on.
Don't be shy.
There's one up there.
Thank you very much for your very interesting presentation. There is a question that I think immediately comes to mind, which is, how do you deal with potential conflict situations when maybe at one point you've acted for the artist, but maybe another point for the music company or the television network? Can you talk a bit about the conflicts? I mean, it's a small world you're working in.
Yes, it's definitely a big issue and a big problem, because there is a very small bar and a very small industry. You can't, I mean, in the entertainment industry, you don't typically represent one side or the other, artist or label, television broadcaster or on-air talent. Because there's not tons of work to go around, you know, you make yourself available to either side. I certainly do. And I find that I'm a better lawyer for it because I get to see the issues from both sides in different files. But people reappear. And so one day you may be dealing against Bell Media, formerly known as CTV, and the next day your firm's calling you and saying, okay, Bell Media needs your help in an entertainment contract. And so I do represent people against the same companies, that not in the same matters, one day, and then the next day, because I work in the entertainment industry, I mean, I can't not represent on Air Talent if the deals that they're doing are with major broadcasters or major producers, because then I basically wouldn't have any work. So it comes up and you navigate it and people accept it. It doesn't mean that it couldn't be challenged. Especially given our recent case law, I think some of it can be challenged. But you do your best. You get parties to consent. You have very good retainer letters drafted by corporate lawyers at Gowlings. And you do your best to keep your interests separate in your head. It's a challenge, I have to say.
Hi, thanks for this. So I'm a criminal lawyer, and people always think we have the worst clients or the most difficult, but it strikes me that you must have some very difficult clients. Can you talk about that a little bit in terms of the I think of the egos and the partying and getting arrested and all of that?
Right. So my general answer is I love my clients, and I think that artists get a bad rap, generally speaking. Although I would have taken the Eagles as clients for sure, even with that kind of behavior. I don't have the Eagles as clients. But I've had a client call me from a jail cell in England overnight. Very, very prominent artist who you would know. I've done deals on napkins at 3 a.m. with everybody not quite, including the lawyers, having straight minds. You do go to parties and there's a lot of bad behavior going on. That's kind of the difficult part to navigate, but it doesn't actually make the clients difficult, I have to say. Like none of those clients, even the one who called me from the jail cell, I mean, maybe it's a little annoying to get a call in the middle of the night. I don't mind, especially now that I kind of immerse myself into my clients' lives. I'm lucky. My client base has been really, really nice and respectful, interested in their business. That to me is a great client, right? Especially in the artistic world, because I think there's a lot of artists who are, well, I do the arts and you take care of the business. And some lawyers might enjoy that because it means you have more freedom to just do the deals. I don't like that. I like them to understand. I like them to truly understand so they can acknowledge and give you proper instructions. And I've been lucky enough to have clients like that. And when I have had divas or really unruly in a way that made me uncomfortable clients, I typically bow out if I can. I mean, I know we have an ethical duty not to, desert a client. It's more in litigation than what I do. If I'm unhappy with how a client's acting, whether it's towards me or in taking unreasonable positions, and that's not just individuals like bands, that's could be business people versus artists, I bow out. I don't work with clients who I don't enjoy.
Oh, yeah. Thank you, Susan. That was fascinating. I don't have a question so much as an observation, which I feel obliged to make because I'm pretty sure that not every single one of the people in this room is going to end up being able to be an entertainment lawyer. And what I would observe is that almost everything you said by way of advice, experience, and how to look forward into your practice is, I'm sure, completely applicable in your particular area, but is also generally applicable and wonderful advice for anybody in any area of the practice of law. And I just think it's really important to say that, right from learning to look for the dotted I's and cross T's, to networking, to remembering that people come back into your practice. All of those things are really, really important in the practice of law generally. So.
Yeah, thank you. I suspect that. I mean, my experience, at least since 1995, is only entertainment, but I suspect as much. For those of you who I told you I would give you advice as to how to get into entertainment law, and it's true that I don't think we could sustain this entire room in our bar. I don't think our bar is like a tenth of this. But this is what I tell people when you actually call me in your 4th year or your 1st year when you're articling, and I sit you down and I say, network an hour, network cover without being annoying, best corporate commercial training you can get, la la la, my advice. But I say, if you truly are driven to become an entertainment lawyer, I say almost just to cage it because I'm a lawyer, I almost guarantee that you will get an entertainment job. I tell people this, and I actually truly believe it. So if you want it, you will get it. The only issue is how long it will take and what happens in between, right? It can take a very long time. It took me, I had all that great paper, and then I learned how to network, and I still couldn't get the job, right? So it took me a long time, but it can take a very long time, and you can get distracted by plan B. I almost did. I loved my plan. I really wanted to be an entertainment lawyer, but I had like these great plan Bs. So, okay, I tried out of law school. No, I'm going to clerk at the Supreme Court of Canada. That was pretty good. And then after the Supreme Court, I was like, okay, I'm going to try again. I got a bunch of no's. So I said, okay, I'd like to live in Paris with enough money to sort of enjoy myself. So, that's how I ended up at Debevoise in Plimpton. It wasn't because I had worked in in New York and during my summers, but I knew that it was one thing to be a summer associate in New York, and it was another thing to actually be a real live lawyer. That was the 3 a.m. Peruvian mine M&A kind of thing. I didn't want that. But I did want to live in Paris, and I figured the most lucrative way for me to get there was through a New York law firm. So that was my plan B. And then once I was in Europe, I was like, this is sort of fun. Maybe I need to create a life in Europe. I'm a Europhile, and I love living in Europe. That had nothing to do with entertainment. So I was easily distracted. I ended up, for various reasons, coming back to, and then eventually got the job. So you may get distracted, and it may take a very long time, and you may have financial pressure. Most people do after law school. So you might have to make compromises. But if you keep at it and do the things that I say you do, and you're patient, you will ultimately get there. I'm going to put that out there.
Great. We're all going to be practicing entertainment law soon then, yeah.
Retired, well, before then, hopefully. Too much competition.
We have time for one more question. I saw a hand up. Cody, I saw your hand up. Here you go.
Hi, thanks, Susan. I was hoping, based on what you've been saying today, I see you go across lots of legal jurisdictions, particularly international. So maybe you could touch on some of the nuances of, I would say, maybe festivals in Canada looking to bring international artists over and some of the things that they should be aware of.
I don't know anything about that, but I like the beginning of your question. Sorry. Because it actually raises a really good point that I should bring up, and I say this very dangerously. So I don't really know anything about festivals bringing acts to Canada. I represent a few festivals, but I'm not sure I know what the issues are. But sorry, that question really raises the issue of cross-border work. Lawyers are brought up, rightfully so, to learn that you get qualified in a jurisdiction, and in Canada, that's not just Canada. That's like Saskatchewan or Quebec or Ontario. I'm called in Quebec, Ontario, and New York. And you're taught, especially in litigation or in some very regulatory areas, don't practice law in another jurisdiction because you won't know the laws in that jurisdiction. Entertainment law is a little bit different. Yes, there's copyright, which is luckily a federal statute, so at least I can cross Canada with it. And there's different copyright acts and laws in every jurisdiction. There's different contract law in every jurisdiction. I deal in contracts. But basically, a large part of what I do for clients is advise on business terms. And I'm acting as a lawyer, but that's what they come to me for. And so I do have clients all over the place doing deals all over the place. You have to be careful, of course, as a lawyer to identify, okay, what are the issues that you actually need local advice for, how this contract's going to be interpreted, what under that jurisdiction's copyright law do you need to know about. And I'll give you an example of that. I don't know if we have time, but I love this story. So I call him the Bruce Springsteen of Portugal. His name is Pedro Abrunosa. Anybody into Portuguese music? It's not Fado. He's like a rock and roller, but there's only two people in Portugal with bulletproof Mercedes: the president and him. Okay, that's why I call him it's the only thing I can say is like he's the Bruce Springsteen. Anyways, I was speaking at a conference in Lisbon. His wife was there. She was a young, new lawyer. She went back to Pedro and she says, oh my God, Pedro, you need to hire this lawyer. So Pedro, when he was in New York at some point, flew up to Toronto and met with me. I said, I really want you to represent me. I'm like, great, that's awesome, but you're in Portugal. But I know the deal structures and I'll bring a North American sensibility to your deals, whatever. So give me your contracts. Without, what I said was, I'll give you a North American sensibility to your contracts without being American, is actually what I said. And that was like this era of being American. I said, just give me your contracts. Let me see, give me the lay of the land and let me review your contracts. So there were contracts, they had to be translated. As I was reading the contracts, a couple of things stood out to me. One was, he's such a Bruce Springsteen, so he'd gone through several cycles of deals. Each record deal could last, especially in the olden days, could last 4, 5, 6, 7 albums long. And he was in his third incarnation of his record deal. But of course, you start as a baby band. He was probably unknown when he did his first deal, and then he had success. And so each time you do a new deal and you live it out, the deal becomes better, has better terms. And in fact, the structure really should change from the label owning to maybe the artist owning but licensing exclusively to maybe the artist owning and just giving to the label to distribute but making the lion's share of the money. That's sort of the movement from an artist recording agreement to an artist licensing agreement to a pressing and distribution agreement, as we call it. And his had stayed at the baby band level. And I'm like, this is crazy, Pedro. Like, why did you never, it was one thing not to renegotiate the deal while it was in play, which people do, but once you had the opportunity to do a new deal, why didn't you change it up? I don't know, and there was nobody advising him. So I said, okay, well, we definitely need to do that. And then I looked at the current deal, and I was reading through broken translated Portuguese, the rights clause. And it seemed to me to say, I couldn't see the digital distribution rights grant, which of course, in the olden days, nobody really anticipated specifically, but in every contract, it always says, we grant you the right to the records in any and all media now or hereafter known. Those are the magic words. And even in the 50s, before anybody knew anything about streaming and downloading, those words were in all the contracts. And I wasn't finding the equivalent words in his contract, any of his contracts. And I said, this obviously is a translation thing, because I'm not seeing it, but it is obviously there. You're with a major label, and everybody puts that language in. So there was an issue that I said, okay, we need a Portuguese lawyer to look at this. First of all, to read the contract in the actual language, and then to also advise on copyright law and how the words of the contract would or would not grant new media rights that were much more relevant today than before. And so I sent to a Portuguese lawyer, and it came back and it was, nope, he never granted digital distribution rights. And I'm like, yes. I was like, that never happens. I wish that happened to one of my clients in Canada. That never happens. But I was like, he's the Bruce, can you imagine Bruce Springsteen having granted his entire catalog, thinking he granted his entire catalog to his major label, and the major label doesn't have digital distribution rights? Can you imagine? So that was the equivalent. So that was fun. But that's an example, sorry, tangent, didn't answer your question, but that was an example of when you actually need to use a local lawyer.
Anything else? Yep, one more question in the back there.
They didn't deny it, which was surprising. I expected a fight, and then I'd have to get an opinion and maybe litigation. There wasn't a fight. It was just, oh, okay, well, what will it take to get them? The other good thing, my favorite story is with this guy. So he sends me to Madrid because this major label's office, Portuguese, was covered by its office in Spain. And the Spanish office of this label that I'm trying very hard not to say was run by a French guy. And this is not so many years ago. So let's say 5 years ago. So we're in the office, he sends me in, and they're like, look, we love Pedro. He obviously knows that there's a weakness in the contract, so they want to get these digital distribution rights to clean it up. And they're like, we keep asking Pedro, what does he want? What does he want? And we just want an answer. I'm like, you know what? I am here to tell you what Pedro wants. And he says, what does Pedro want? And so then, of course, you may not understand this, but as I said, he was over here with an artist recording agreement and should have been over here with a pressing and distribution agreement, which is worlds away financially. And I said, what Pedro wants is a pressing and distribution agreement. And all of a sudden there was this big silence, and the French head of this major label in Madrid said, "Do you mind if I smoke?" I was like, yes, I have won the battle.
All right, I think we'll wrap it up. Thank you so much, Susan, for coming. The trip from Toronto to coming to Saskatoon. We have a little thank you here from our student organizer. So come over.
This has been fantastic. Thank you for being here today. I would just like to invite everyone here to come down to the student lounge after this. We'll have a chance to chat more with Susan and Kurt and Michelle. I would like to thank you, Jamesy, for setting up this event and for bringing Susan here today. On behalf of the college and the student body, thank you, Susan. This has been really great, and we've greatly appreciated having you here. And we have this little gift for you.
Love gifts. Thank you. Thank you very much.
It's been great.
Yeah, thank you. Thank you, everybody.